So bankruptcy or creditor-related issues, money issues, basically. So this can come up as either somebody wanting to file bankruptcy, or somebody having a creditor's claim, meaning you're owed money in bankruptcy. Usually if it's a creditor's claim and somebody owes you money and they file bankruptcy, usually you're going to want to hire a bankruptcy attorney to go in and make a claim against the bankruptcy estate to try to collect. It's kind of a debt collection type attorney, but just in the bankruptcy context. Because there's a lot of very specific rules in bankruptcy. You can make a claim on your own um, by filing a claim. A lot of times they'll give notice of how to file a claim. Sometimes it can be done online. If you're able to do that yourself and it's not a lot of money you're talking about, just put your claim in, but understand that just because you file a claim doesn't mean you're going to get paid anything. You might get a small portion of what you're owed, depending on what money's available at the end of the case. And that could be years from now. So there's going to be a trustee appointed that will make that decision, oversee the case, and then any distributions of assets down the road at the end of the case. So, at least talk to an attorney about it, but you can file a claim, just follow the process and understand that you may or may not actually get paid, depending on how the case works out. Sometimes the reason you should talk to an attorney also is, as a creditor, sometimes there's things you can do to elevate the priority of your claim. So if you file a claim as a general unsecured creditor, just, hey, the guy owes me some money, you might be at the bottom of the poll. When there's any money left, like it goes out down the poll, okay, well, who's left at the bottom? If there's something in the claim that you have that could elevate it to a higher priority, you'd get paid before the lower stack. So there's different levels of priority. And if there's a claim you can make, paperwork you can attach to show you're a secured creditor or a priority creditor, something higher in the food chain, that could benefit you because you will get paid sooner and more, depending on the type of claim that you have. So you might want to at least look into that first before filing your claim. Now, on the actual filing of bankruptcy, you've got primarily three different types: Chapter 7, 13, and 11. All of these can be filed by an individual. A company, like an LLC or corporation, typically it's just 11 or 7. 7 is a liquidation, just getting rid of all your assets and selling them off, whatever's left, pay off your creditors. And if there's money left over, it's like it could potentially go to the prior owner, or there's a whole bunch of things that could happen. But usually it's liquidating your assets, paying off a pro rata or a percentage portion of the debts that are out there. So there's $100,000 worth of assets and $500,000 worth of debt. They're going to split it up based on percentages between all those $500,000 worth of creditors. And then 11 it's basically you can choose a number of different ways to go with an 11. 13 is only for individuals, and the individuals, it's a repayment plan over usually a 3 to 5 year period. And you're going to pay at least a portion to your creditors of what you owe based on your discretionary income, based on paperwork that you file. So the simplest one to file is a Chapter 7, whether it's a business or an individual. The court forms are all on the bankruptcy websites. So the bankruptcy court has standardized forms, and including the local court. So it's a federal case in federal bankruptcy court, but you file it basically in the local bankruptcy court where you're located. So if you're in a certain county, there's usually a bankruptcy court nearby. That's where you file it. You can look on their website and find, okay, are there local forms? What is the list of forms that I need to file Chapter 7? There could even be a self-help center or pro bono services to help you. Basically, you fill out the paperwork. There's, 30, 40 pages worth of a petition, schedules, exhibits, file it. They're going to schedule a creditors meeting. You're not allowed to even bring an attorney to a creditors meeting. So you have to show up by yourself, answer questions. Usually they're very little questions from the trustee. And usually in a Chapter 7, there is no hearing. You don't even go in front of a judge. At the end of a certain period, as long as no one objects, they grant you a discharge and you're done. So a Chapter 7 can be something you can do by yourself. but make sure you research local rules in the bankruptcy court, go all the right forms, and you are signing this stuff under penalty of perjury. So that's where having an attorney to advise you could be helpful, because if you say, oh, I don't know if I should put this on here, or I'm not sure about this certain claim or asset or something, and you're not sure and you don't list it on there, and you should have listed it and you sign it under penalty of perjury, there's bankruptcy fraud potentially. So it can be very serious. It can be prosecuted criminally if you lie or you fail to disclose something on bankruptcy paperwork. So it's a big deal. Even though it is a relatively simple case to do, put together your petition and schedules, make sure you meet all the timelines, file them with the court, show up for your 341A creditors meeting. Any paperwork they ask for there, make sure you get it to them. And then there's some pre and post bankruptcy filing courses on credit counseling and financial management. You need to make sure you take, submit it to the court. And at the end of your case, then you'll get a discharge in the mail, basically. So a Chapter 7 can be done on your own for an individual or a business, as long as you're sure that you fill out all the forms properly and you disclose everything, all potential assets, all potential liabilities that you could potentially own. Chapter 13 is a little bit more complex because it's a repayment plan, and there's some complex forms to calculate what the repayment looks like. There are also people that will help for free sometimes with the courts, and there's paperwork, there's forms already there that you fill out to put together a Chapter 13 plan. Now, the Chapter 13 trustee and each judge have a lot of times specifics that they want to see. So a Chapter 13 gets a little bit more complex because there's intricacies of the payment plan, what you can and can't include as expenses, how much you have to pay, how long. So it's a little bit more difficult to do that on your own. It's not saying you can't, but it's going to take more work. There are going to be court hearings to confirm your Chapter 13 plan. So there's also going to be a creditors meeting. No attorneys allowed there, but at the hearings, you can have an attorney to confirm your Chapter 13 plan. So that's probably the biggest bonus of having an attorney in a Chapter 13, is that they're going to understand what the Chapter 13 trustee and the judge want to see in a Chapter 13 plan, what's allowed for reasonable expenses, because they're going to take your income minus your expenses, whatever's left over gets paid pro rata to your creditors. And so when you plug those numbers in, if you've got a huge, luxury car payment, or, you're putting money away for a vacation, some of that stuff might not be allowed depending on the trustee and the judge. So the attorney's going to understand and know that ahead of time to be able to get you to a confirmed Chapter 13 plan. Otherwise, your case gets dismissed, you're done. You have to refile and start over. So that's the biggest benefit. There are, based on the location and the federal court, limits on what an attorney can charge. So typically, I believe, as of 2013, it's around $4,500 flat fee. Some of that can be paid out of your Chapter 13 plan, but I believe that's the maximum. You have to look at your local court to see if there's a maximum your attorney can charge under federal or local bankruptcy rules. And that's the most they can charge, either upfront or through your payment plan for a Chapter 13 case. But it might be worth looking into hiring someone because it is a more complex case. Chapter 11 case, you almost have to have an attorney, because those are, whether it's an individual or a business filing it, they're very complicated, a lot of hearings, a lot of deadlines, and judges are on top of it. And so they will not be happy if you file it yourself and you miss deadlines, you don't follow the rules. There's local rules, procedures, standardized forms. And if you don't follow those, they're not going to be happy. So that's one you really pretty much have to have an attorney for. And you're probably going to be paying hourly for that, $200 to $500 an hour. A lot of times that attorney has to submit statements to the court to approve their fees. Almost in every bankruptcy case, their fees have to get approved, no matter what type of bankruptcy. So you're going to be assured that the bankruptcy court and trustee are watching how much your attorney gets paid. So there's less likelihood that you're going to get overcharged in a bankruptcy case if you do hire an attorney. So again, chapter 7 probably can do it yourself, but good to look into talking to an attorney at least. Chapter 13, it's a little bit more complex, probably better to have an attorney. And then chapter 11, I would never try to do that without an attorney handling it who does chapter 11 bankruptcies in your local jurisdiction, because that's a very specialized type of bankruptcy.